So we provide evidence-based research, capacity building, and policy engagement on issues that are surrounding intellectual property law, data protection, artificial intelligence, and digital rights. So to start us off, I'll give a very brief background or overview of the two documents that we're going to be talking about in the next hour and a half. The National Intellectual Property Policy and Strategy, or NIPPS for short, sets out the overall vision for Kenya's IP system. So it outlines the country's priorities, establishes the governance and coordination framework, and it sets objectives on issues such as commercialization, enforcement, education, research, collaboration, and emerging technologies. On the other hand, we have the Kenya Intellectual Property Bill, which is the legal instrument that's supposed to rather that the policy is supposed to help to be one of the developments for the IP system. So it works as a single framework for the IP laws and establishes the proposed Kenya Intellectual Property Authority by merging the Kenya Industrial Property Institute, or KIPI, and the Kenya Copyright Board, or KECOBO, as well as the Anti-Counterfeit Authority, or the ACA. It also aims to strengthen the administration and protection of IP rights, promote commercialization, and introduce provisions on emerging technologies such as AI-assisted inventions. So ideally, this should be an overhaul of the Kenya's IP system. It's something that is not new. The IP bill is not new. There was the IP bill for 2020, which also went through similar public participation. And again, our thoughts were shared there, but that did not get any traction. And so we have the 2026 IP bill. Similarly, there were two other attempts to have the IP policy, and this will be the third time that we are talking about an IP policy and going through the same discussion on how to improve it. So they do provide an opportunity to modernize the IP ecosystem and to strengthen innovation, but there are several gaps, and these are legal, institutional, and implementational gaps that we have identified, which need to be addressed before there's any reform that is finalized. And that is going to help us to support the innovation, creativity, and of course, Kenya's long-term development goals where intellectual property is involved. So one of our central issues, or one of the key issues that we've seen with these two documents, is that there is the proposal to have a Kenya Intellectual Property Authority, or KIPA. The question here is this really the right model for Kenya? So to create some evidence backing on our view on this, we did a bit of research around it, looking at the pros and cons of countries that have actually gone through consolidating their IP laws and having one institutional body. Some of that research showed that consolidating IP institutions does not really automatically result in greater efficiency, because the success will depend on three main factors. So one, the adequate institutional capacity, sufficient resources, and the preservation of specialized expertise. And this I have also seen in relating with other IP officers across Africa. There's one who was very clear and said that they had consolidated their copyright office, and because of that, they could clearly see that the development of copyright was actually not being prioritized over other IP rights. So the lesson here is that, or rather, even in other areas within Kenya's ecosystem, legal ecosystem, there was a consolidation of agricultural regulators under the Agriculture and Food Authority, which also demonstrated that a merger can lead to uneven prioritization. It can also have resource constraints, and ultimately it can lead to a reestablishment of specialized institutions in some sectors. So the concern here is pretty relevant, and given the current capacity constraints within some of our IP institutions, where from the policy we show, rather we see that KIPI has a 51% vacancy rate, and this is also seen in KECOBO and ACA, where there is staff shortages, and so consolidation alone is unlikely to resolve that capacity challenge. There's also the inconsistency between the two instruments. So the IP bill proposes merging the three IP offices and introducing KIPA, whereas in the policy, under the implementation framework, it continues to assign responsibilities to these institutions as though they would remain separate. There's also a lack of transitional mechanism that we're seeing if the merger is to proceed. So basically, our recommendation is that Kenya should retain the specialized institutions while strengthening statutory coordination and information sharing between them. And in the event that we consolidate it, it should be implemented in phases, supported by adequate financing, staffing, and very clear transition plans. Moving on to the next issue that we have identified is around traditional knowledge and traditional cultural expressions and genetic resources. Um, both of the documents, the bill and the policy, recognize the importance of this of TKATCs, but there are also gaps that have to be addressed. So if we start with the bill, it proposes KIPA has a broad mandate to promote all of IP and even mention protecting traditional knowledge and traditional cultural expressions. But there's not much more about that. The protection for traditional Knowledge and Cultural Expressions Act for 2016 is not listed as one of the laws to be administered by this authority. And so there's a gap there. There's uncertainty regarding the institutional responsibility of TK and TCE. The bill also provides evidence that there should be, rather requires evidence for prior informed consent before traditional knowledge can be used. But there's not much about fair and equitable benefit sharing arrangements. So this is not in alignment with Article 61, 69 of the Constitution. When we turn to the policy, it correctly identifies that many county governments have not established the TKTCE repositories or registers, but there's really not much to show as to what the measurable baseline for this is. For example, identifying which of all our counties have actually complied. There's also the INKI Bank, the Indigenous Knowledge Innovation Bank, which was recently launched, which does not appear anywhere in the policy. So the policy misses an important opportunity, not just to recognize the traditional knowledge and traditional cultural expressions, but also to promote them through the strategies. So first, it really needs to expressly assign who is going to be administering the TKTCE Act, because as it is right now, it's not in operation, and that is something that has to clearly come out in the policy. Then we move on to the rather to talking about AI, TDM, and digital rights management. So AI is featuring in both of the documents. However, it is given as a rather there's not much thought into it in the sense that yes, the bill does talk about distinguishing AI assisted inventions, which may be patentable, but also talks about AI generated inventions which are not patentable. But it doesn't really explain what level of human involvement amounts to meaningful intellectual contribution, which it provides in the Act. The bill also does not define what technical character is when it requires an invention to have a technical character to qualify for patent protection. And it also introduces the text and data mining exception, but it's limited to non-commercial research, which is positive at first glance, but also does not really help in the development of Kenya's growing ecosystem, AI ecosystem, because innovations emerge from collaboration with universities, startups, and private sector, and then those end up being commercialized inventions. So there's that gap where we're not talking really about what happens when rather AI is being used for research, but the research output ends up being of a commercial value. So our recommendation here is to provide greater policy and statutory clarity, provide examination guidelines on what constitutes meaningful human inventive contribution, and also to ensure that rather to introduce an opt-out or equitable remuneration mechanism when it talks about the TPM exceptions. Then our final theme around these two documents is the legislative incoherence. And this is because there are if we start with the bill, there are very many incorrect cross-referencing throughout the text. In some cases, it's provisions that refer to wrong sections entirely. And this could just appear to be a grammatical or technical error, but if you think about it a bit more, they could also have significant legal consequences. And so it's very important that they need to correct all these things and to ensure that the legislative drafting is accurate. Then the bill also raises broader harmonization concerns because it refers to the Copyright Act as we have right now. It overlaps with the separately drafted Copyright and Related Rights Bill, as well as the Geographical Indications Bill, which is referred to as an act in the bill, yet it has not yet been enacted. And so these are some of the issues that we have seen. There's also what we might call as typographical errors, but could have an important impact, with the anti-counterfeit being called an agency, reference to the IP bill of 2020 as opposed to the current IP bill. And so there's need to ensure that there's harmonization and also legal drafting that has been reviewed. So once again, I mentioned that in coming up with our recommendations, we did a bit of a comparative analysis on the harmonization of the IP laws. If you look at Rwanda or Vietnam, they've adopted a unified IP office last year in 2025. And then there's other countries like SA and Kenya and UK, which retain the specialized institutions. So if you look at a pros and cons list, to identify actually what governance model would work for us and what are the likely detriments to a unified one. One of the pros that we can see is that there's a single point of access and there's also streamlined administration when you have a unified IP office. But there's a higher risk of losing specialization and also complex transition and reform, and it can also overstretch the limited resources. Then when you look at where we have specialized IP institutions, as is the case right now we have in Kenya, it can help to preserve the specialized expertise and ensure that there's stronger sector-specific service delivery and development. So this would mean that there's enough expertise and resources that are taken into copyright to ensure that it develops through industrial IP rights to develop and the like. And so here we found that the key lesson here is that it's important to strengthen the coordination and preserve the specialized expertise, but ensure that there's coordination between the institutions, which would assist. Then we also gave a regional perspective, very briefly, in saying that the national IP policy has to be future-proof. So in our comparative research, we found that consolidated IP governance, for example, the TIPA, is not a guarantee for success. Its effectiveness will definitely depend on adequate institutional capacity, sufficient resources, and preservation of specialized expertise across the IP rights. So the policy also has to strengthen its regional orientation. If we look at the Africa Continental Free Trade Area, there is the IP protocol and its annexes. And so the policy has to very specifically address what is rather give an implementation plan on how we can implement the AFCFTA. And with that very quick presentation, thank you so much for your time. I want to ask the questions because I want to now invite our practitioners, our IP practitioners, our IP scholars who will give us give us their perspectives from their different areas of expertise. So I will start by introducing and inviting Ms. Hazel Okoth. Welcome, Hazel, and as you give us your perspective on this today.
All right, thank you, and thank you to CPIT as well for the opportunity to have me participating in this discussion on the reforms that are currently taking place in Kenya in terms of the bill and the NIPS. I see it's called NIPS all around the continent, the National Intellectual Property Policy and Strategy. But like Chebet said, my name is Hazel, and I work with the International Trademark Association. The association is basically an association of intellectual property practitioners, brand owners, IP scholars, IP professors. So everyone who really is involved in the space of IP, and we do a lot of advocacy work. We work a lot with intellectual property offices around the world. We interact with policymakers as well when it comes to issues of IP. And the discussion is quite timely, I suppose, because I feel like there's a wave of policies being revamped, policies being adopted all around the world. We had Nigeria adopting its national IP strategy in December. I think Uganda is looking to review its policy. I think 5 years in, because I think it was adopted around 2019, which just goes to show that the landscape is really moving, especially with issues around AI and things like that. It's very critical that policies remain updated and adaptable to what's happening in the IP landscape. But bringing it back to the reforms that are currently taking place in Kenya, I think um, from my background, coming from an association of brand owners, I think the most important thing is that the system remains reliable, the system remains predictable, and the integrity of the registers that we have in terms of IP for brand owners who are looking to bring their business into Kenya. Consolidation, I think, is the main gist of what the bill is about, because I feel like it, apart from the consolidation part, largely most of the rest of the bill is just a copy and paste from the statutes that it's seeking to repeal, the Industrial Property Act, of course, coupled with a few changes here and there, the Copyright Act, and basically a copy and paste of the Anti-Counterfeiting Act. So I feel like the gist of the bill is actually the consolidation of the three authorities. And like what you mentioned, Chebet, consolidation does not automatically lead to efficiencies. And I think Chebet has done a really good job in providing examples of offices that have attempted to do this before. There are pros and cons to it. I think Chebet covered that really well in her presentation in terms of, having one place that creators and innovators and everybody goes to, as opposed to you're going to Kekobo in Upper Hill, Kipi in Lavington, and all that. So, having one place where you're going to find out this information and get some assistance in terms of whatever whatever IP that you've created. Those are some of the cons, that some of the pros that I feel like are being proposed in terms of having one authority, a consolidated point of reference, potentially reduced operational cost, which I think is one of the things that the World Bank is really trying to push for in terms of reducing Kenya's wage bill. But the con is very critical, and I think one of the cons that is critical even for us as an association is a specialization that is involved in the different trades. Personally, as a practitioner, there's some concepts even in copyright that I still don't understand very well. So, what is the balance that needs to be struck to remain with that kind of specialization, even in the umbrella of one institution, one consolidated institution? Because having everybody sit in one physical area, or one physical office, if I may, describe it as elementary as I could, does not necessarily lead to an improved IP system. I think there are so many other considerations that need to be taken into place. It doesn't necessarily translate into better outcomes for users, it doesn't necessarily translate into a more efficient IP system. And I think even with other institutions that have attempted to consolidate their IP bodies, I think if you speak to them candidly, they'd be able to tell you that there's so many bottlenecks that perhaps they had to go through before really, having an established system that is working, and it could take years before everything is working smoothly, because I feel like there'll be so many bottlenecks, and there'd be a risk of lack of specialization within the different functions that Kekobo, Kipi, and ACA are already, they're doing capacity building in their own respects. They have all these modes of working. So there's that risk of losing that specialization. And I don't know what that would then translate into in terms of the IP system that we are trying to improve, that we're trying to modernize. Another thing that I think I would mention, particularly from a brand owner's perspective, is also modernization of trademark issues. For instance, something like non-traditional marks, which is something that the policy explicitly says that Kenya still doesn't have sufficient protection for those kind of things. And I think as brand owners are moving from, protecting their brands traditionally as words and slogans and logos and things like that, when you're moving into scent marks and sound marks and motion marks, I think that's one of the things that the policy as well needs to envision in terms of creating a framework on how we can modernize our trademark laws to incorporate some of these things. And trademarks, interestingly, is not part of the consolidation. The Trademark Act remains, which for me, I don't know what, I have questions about that as well, because if you're trying to consolidate these other statutes, I don't know why they left the Trademarks Act behind. It could be for good reason. I don't know the reasoning behind that. Perhaps it's something that we'll discuss as well, and maybe people can share their views, but the Trademarks Act is not part of that consolidation. So quite an interesting thing. And another thing that Chebet actually mentioned is harmonization within the already existing regional systems. Kenya is part of a repo. We are, we are doing the AFCFTA protocol at the moment. And even with the repo, in as much as we have the Harare protocol, which we're a part of, but we're not part of the Banjul protocol, how do these laws interact with the regional framework that already exists within the continent? Because I believe brand owners in Kenya are not necessarily looking to operate within the continent, within the country itself, but there's also, especially with the AFCFTA now coming into place and the protocol on IP, the protocol on trade, the agreements to do with movement of persons. I feel like businesses are going to really now be moving into all our neighboring countries, and the bill and the policy, I think, need to envision that kind of movement of goods, movement of trade within other countries in the continent, and movement of persons. Another thing Chebet also mentioned, and maybe I appear to just echoing what Chebet is saying, but the issues about AI as well. AI is a hot topic right now, and I feel like the space of AI and IP is still very much developing. There's a couple of mentions of AI in the patent section of the bill, in terms of I saw that inclusion in terms of what's not patentable. AI, is it AI assisted invention and AI generated works, that kind of distinction. So it's still very much a developing space in terms of AI and IP, and there's a lot to look out for. I feel like jurisdictions globally are still trying to see how to incorporate or treat this kind of, I don't want to call them inventions, that kind of creations. Let me use the word creations instead. Those kind of creations. Um, so it's still very much a developing space, and the bill is not patentable, but there needs to be more discussions in terms of what could it potentially be, and even the policy at the point where it's adopted and it's rolled out, it should have provision to sort of review those kind of issues as the landscape continues to develop in terms of what AI and IP is and things like that. But I think Kenya is at a critical reform stage when it comes to IP at the moment. And I feel like we need everybody involved in the process: SMEs, startups, creators, universities. And from my personal perspective, I think we need to do more in terms of creating an IP culture in the country. Simply, and not just simply improving the IP system, because I think we really talk about the IP system quite a bit, but I think there's also something that we need to collectively work on in terms of improving the IP culture in Kenya, so that it doesn't become a thing that creators and innovators are thinking about very much later on in their innovation journey. But how do you integrate IP conversations from the very start of your entrepreneurial journey? How does it become a natural consideration throughout the innovation process? I think that's really, for me, that's what would be the true defining factor of what the bill and the policy need to do. How do we improve the
Yeah.
IP culture in Kenya? How do you create? I think when you have a better IP culture is when we'll be able to see creators and innovators actually benefiting from the IP that they come up with. Because as a strong IP system will protect your innovation and your creations and everything. But I think a culture will do more in ensuring that you benefit from the IP that you created as a business. How do you create that a stronger IP culture within the country?
Yeah.
And one more thing before my 7 minutes are off. Sorry, Chebet.
They are out.
Oh, they're up. Okay, I'll
Yes,
bring
yes,
back my
yes.
point later on. Thank you so much.
Thank you. Thank you so much, Hazel. Thank you for giving us that brand owner's perspective. I think it's very important when we're talking about policies and laws, we have to have the people who are going to end up using or being IP rights holders being at the forefront of what we're talking about. So thank you for that perspective. I also love how you ended it talking about changing the IP culture. In tandem with the IP legal framework, because it's very important for us to change our IP culture. I may be wrong, but I don't think in reading the policy I saw anything about inculcating intellectual property in the curriculum of early learners. So primary all the way up. I think that's one of the strategies that we should have. If I'm not wrong, we'll add that in our memorandum submission. But thank you very much, Hazel. I want to quickly move on to Mr. Andrew Mutua, who's joining us as well to give us his perspective. Welcome, Andrew. You have 7 minutes strictly, so I'll just stop you when you're done.
Okay, thank you so much for the lovely introduction. So thank you again, and thank you Cricket, for allowing me to present today. Part of what I'm going to discuss today is basically the Kenya Intellectual Property Bill, and specifically the establishment of the Kenya Intellectual Property Authority. So the bill provides as its principal object the establishment of KIPA as a single institution to administer in one place all of Kenya's intellectual property law. This is to be achieved by merging the functions of three existing state corporations, which is KIPI, KEKOBO, and ACA. The justification given for this is that the current fragmented administration of IP by these corporations has led to duplication of functions, inconsistency of standards, and an unnecessarily complex and costly experience for investors, creators, businesses, and the public. From my reading or my understanding of the bill, I think that the first 2 points might come off as sound to an annoying legislator. However, they don't hold water to me. And are a telltale sign of an understanding of the IP regime in general. IP is by and large a creature of statute, meaning its existence, recognition, and exploitation is based on statute. Therefore, claims of duplicity of function and inconsistency of standards stem from a mischaracterization of IP as one regime needing harmonization. So my role today was just to discuss the establishment of KIPA and the functions thereof. So clause 5 establishes the functions of KIPA, and they're listed there. However, I want to go through whatever changes or what the bill proposes. So under clause 5, keeper will consolidate core mandates of KIPI, KEKOBO, and ACA. And for example, subsection A unifies KIPI's role in patents, designs, KEKOBO's role in copyright, and ACA's enforcement against counterfeit goods. Secondly, the information and awareness functions in subsection B and G will merge overlapping mandates. This change ensures inventors, creators, and businesses access one central source of IP knowledge and training rather than navigating three separate bodies. Lastly, the coordination and research functions in subsection H and I broaden existing roles. Kakobo oversees copyright treaties while APA advises government and conduct research on counterfeiting. KIPA will extend these responsibilities to all IP rights, piracy, and international obligations. The Act, however, provides for new mandates that KIPA will govern or have mandate over. So there are certain functions that have been introduced that none of the predecessor bodies had. Subsection D creates an IP recorder system titled Import and Lobby. Subsection E adds protection of genetic resources, traditional knowledge, and cultural expression. Subsection J promotes valuation, utilization of assets in business. Finally, subsection K establishes alternate dispute resolution mechanisms, offering a faster, less adversarial way to resolve IP disputes. The only notable omission is CP's role in screening technology transfer agreements, which will not be carried forward. And you can refer to Section 5B of the Industrial Property Act, 1. So the question is, do we need KEPA now? In my opinion, I'm not sure yet. However, let's see how the presentation goes. So from my understanding or from my reading on the bill, I think the legislators wanted to bring in something to not only spur innovation in Kenya, but also build an economy where creators or people who use their mind to invent stuff are rewarded. So I thought about it and I looked back to Kenya's IP data. WIPO's 2024 data places Kenya 62nd in patents, 85th in trademarks, and 64th in industrial design, with filings largely driven by Kenya. This mirrors KIPI's long-term statistics 2000 to 2022, where trademarks designated over 90,000 applications, while patents remain below 3,000. The country's IP ecosystem is therefore trademark heavy and patent light, reflecting strong creative and commercial activity, but limited technological invention. Regionally, Kenya ranks 12th in Africa and 102nd globally in the Global Innovation Index 2025, with innovation output at 85th, consistently outperforming input at 116, showing efficiency in converting limited resources into results. So what are the implications of implementing an authority model for Kenya's IP regime? On the positive side, the proposal to establish KIPA promises benefits such as the unified administration of IP rights, centralizing the functions of KIPI, KEKOBO, and APA. Secondly, it introduces new functions such as IP valuation, ADR, and protection of genetic resources, TK, and cultural expression, aligning Kenya with international obligations and positioning the country as a regional policy leader. Third, centralization to streamline awareness campaigns and enforcement functions, offering a single coordinated program that improves the public's understanding of IP and strengthens compliance with treaties. On the negative side, however, the implications are significant. The bill essentially amalgamates weak corporations into departments, meaning little changes beyond their loss of independence. To accommodate the expanded mandates, new departments will be required, such as Plant Leaders' Rights Department, traditional knowledge and cultural expression, GI department, alongside administrative directorates such as legal services, HR, ICT, audit, finance, and communications. Further, transitional clauses mean existing staff must be retained while new posts are created, expanding bureaucracy and increasing costs. For a developing country like Kenya, where enforcement capacity, commercialization pathways, and R&D funding remain weak, this expansion risks becoming a burden rather than a solution. Lastly, Kenya risks being a regional forerunner in policy without translating reforms into tangible innovation outcomes. Embedding IP governance with the business registration service, supported by specialized institutions such as QD, Kenya, and KEFIS, offers a more organic, enterprise-focused model that grows with trade and innovation rather than expanding bureaucracy for resources.
Thank you, Andrew. Unfortunately, your time has come up, but we thank you so much for your well-researched and well-articulated um, perspective on what the IP authority positive and negative effects will be. One of the ones which I've noted is the likelihood of expanding bureaucracy, which is quite interesting given that they will be consolidated. But I think it is a negative implication that's likely to happen. So thank you so much for that. It's also very interesting that though we are looking at these documents individually, we are coming up with more or less similar recommendations on what should be changed. I think Hazel has touched on the same thing as I have, and also Andrew has mentioned the same. So thank you so much for bringing out these perspectives. Let me move on now to our other discussant, and I'll introduce her and invite her, Ms. Liz Lenjo, to join us and give her perspective.
Thank you, Chabet, and thank you to CPIT for the good work that you're doing. I think it's really encouraging to see how the IP community is growing and the interest in IP in Kenya is growing. So we've come a long way since I started my specialization in IP about 14, 15 years ago. So let's start with the IP bill. My thoughts in summary, without repeating what everyone else has said. So first of all, I think the approach in how the bill has been drafted is flawed. As Hazel put it out, they've literally just copy-pasted the acts, which is not, it doesn't make sense. And then they also left out the Trademarks Act, big question mark. So I feel like that approach was very flawed. And what we're getting from the policymakers and the legislators is that they want one IP office for a few reasons. Some of the reasons that they have cited are that innovators want a one-stop shop. The other reason they have cited is the issue of public resources in terms of saving money for hiring staff in the different IP offices and whatnot. So those are some of the issues they are raising. Would we benefit from one IP office? I think it's a continuing question. I'd answer it from my frustrations as an IP practitioner. So first and foremost, just going back to the bill, I feel like if it's one IP office that we want, keeper, then ideally we should have had a keeper act. Bill, an intellectual property offices or authority act. Let's just be clear. So that then that addresses the administration of these IP rights and laws. That's, I think, what they should have done if we were being clear and serious about it. And maybe under that bill, they could have set up directorates. So then there would be a copyright directorate, a trademark directorate, a patent and utility models directorate, and whatnot, and so on and so forth. A counterfeiting, the anti-counterfeiting directorate, whatever. So maybe that's what they would have done. In my analysis and some of the frustrations I've faced with some of these IP offices, and particularly with KIPI, maybe in such an environment when we've seen in government, when directorates or departments are quote unquote competitive, sometimes people style up. They manage their departments better. Because right now, I think Hazel, I'm sure she can attest to it. The frustrations we are having as trademark attorneys, as even as members of INTA, in terms of the conversations we're trying to have with them, is that something needs to happen in the trademarks department at KIPI. There's an issue we are hearing of short staffing and whatnot. And at the same time, I think when they're conceiving a keeper, I don't know if in their mind they think that someone in the patent department would move to the trademarks department. If that is their thought, it is very flawed. Because already, as we are seeing it at keeping the trademarks department, our frustrations are quite something. When it comes to even the quality of examination, who they're hiring in terms of examiners, I don't think we have any lawyer or advocate who is in the examinations department. All of them are non-lawyers. So you can see there is a problem. If there is no basic understanding of what is a trademark and what would be the threshold of examination, then you will see we are always having some very interesting and weird marks being advertised. Like not so long ago, a mark was advertised in the trademarks segment for someone who's trying to register sugar-free as a trademark in the confectionaries classes, question mark. See, there's a problem. So I think if really we are convinced we needed an IP, one consolidated IP office, maybe it would have been a directorate, an act that has established an IP office and established the directorates and how they would handle each other, so that then it also speaks to amendments of these different acts around intellectual property. Because as is right now, under one consolidated act, you can imagine if a new conversation that is happening globally that would be cause for an amendment for a certain section, it will be so bureaucratic. And already we can see, at least even whenever we are amending like the Copyright Act, the amendments tend to be faster, right? So now you can imagine in a situation where everything is under one roof, there will always be no wait until we figure out if we need to amend this part and this part and this part, and then we can move to Parliament. So to be a whole bureaucratic system. So I feel like the bill as is heavily flawed. I don't even think it can be salvaged. I think it should just be killed, and then a proper stakeholder engagement happens at the preliminary level to discuss if we need an IP office, then what is the strategy or structure in terms of that. So those are my thoughts in terms of the IP bill. Now moving to the IP policy. I have read it a couple of times, and I have realized one of the areas that it has struggled with is setting out policy issues. It has only about 7 paragraphs setting out policy issues. And as you rightly put it, Chebet, an IP policy should be future-facing and future-proof. Those were your words, right? So if we don't get our policy issues well addressed, then you find that we have a half-cooked approach. We have a half-cooked policy document, because this policy is what is supposed to also guide us when we are drafting the various legislations, right? So right now, the 7 paragraphs we have are very limited. And even in terms of how it has addressed some of these issues, there are some instances where it's repeated, clarity is a problem. And then let me just find my notes, because I did a whole research on it. So it's the policy issue is a big problem. And then when you look at it as well, just a moment. So aside from just it lacking in the policy issues, I feel like it could have discussed most of these IP regimes in equal depth. It has shown some certain bias for some of them, and then some generally glazed over. So one of the areas, in my view, has been underdeveloped is the issue of copyright and related rights. And especially related rights is always the forgotten child, the performer's rights. So issues like that, I think it could do better. And again, speaks back to the issue of identifying the policy issues and then tackling them one by one. When it comes to the issue of TK and TCEs as well, you can see, in my view, the policy is struggling in terms of how it has addressed TK and TCEs as a genuine sui generis system. Again, the commercialization bit is not well tackled. Again, boils down to how policy issues are identified, right? If the policy issues are identified correctly, then we have a better, would be in a better position to even streamline what commercialization would look like in terms of policy. How do we, sort of how do we direct some of these IP offices or stakeholders in terms of how they can assist in the issue of commercialization. And I feel like if I started talking about that, my time will run out very fast. But whether it's addressing it, I don't think so, and not adequately so. Just some sprinkles of it. And then the issue of dispute resolution, I think at some point I kind of took offense in how the way the policy has talked about the tribunals. On one end, it's saying we have tribunals, and then on the other end, it's saying we don't have IP courts. And I'm like, what are we saying in this document, right? And the truth is we have specialized IP courts. We have the Industrial Property Tribunal, we have the Copyright Tribunal, which I chair. We have the one that's on seed and plant varieties. So the question should be, how can they be strengthened from a policy perspective to make sure that disputes are resolved comprehensively in terms of the different disputes that are involved either in industrial property or in copyright or plant and seed varieties. Because, for example, like for us, copyright, when you look at how we are constituted, we're not only, our mandate or our jurisdiction is not only under Section 48. There are several other sections that give us jurisdiction on copyright disputes. And then now identifying those weaknesses and saying, okay, what else in terms of dispute resolution can the Copyright Tribunal tackle? Same with IPT, because IPT right now only deals with decisions by the managing partner. The managing director. So now at this point, we're like, what are other issues? If proper policy issues were identified, they would actually even see that one of the policy issues that we have, especially from practitioners' point of view and marketing Kenya as an investment destination, is that we need better dispute resolution in terms of decisions at KIPI, for example, on industrial property issues. One of the things that is really the bane of our existence is trademark oppositions. Now, if all that load is falling on the managing director and the trademarks department, which has, I think right now, only 2 people, there's a problem. And we're talking about thousands of filings a month. So I think dispute resolution there, we need to sit down and talk about it. And then I think I'll conclude by saying the document could use more work. Policy issues are the ones that would have set the tone in terms of how we address this case on an IP issue by IP issue, and identifying what pillars this IP bill need to have to ensure a more robust IP system. So I'll leave it there for now. Thanks, Chebet.
Thank you so much, Liz, for sharing your very practical insights and how that ties into the 2 documents. Lastly, I'd like to invite Mr. Mwangi Nasser to give us his perspective as well as a trademark lawyer, what he has seen on the ground, what these 2 documents will help or not help with. So I'd like to invite him.
Thank you. I think the speakers who have gone before me have virtually commented on everything about the bill, the policy, and what are our really main areas of concern. I think particularly Liz Lenjo has gone way out and discussed the dispute resolution structures under the proposed IPB. I don't know whether it's because one of the sections says that her term shall come to an end upon promulgation of this act. But I've really liked the spirit of Liz Lenjo, and that spirit should not expire with the enactment of this act. And especially what she has talked about, problems we have in the IP offices. They exist now when those IP offices are specialized, and they will not end once we consolidate those offices. As Hazel said, those problems are likely to be compounded, because the problem we have is a cultural problem, is a practice problem. Another problem we have in KP is, one, we are told there is insufficient workers, unskilled workers, and there is also a general sense of not paying particular attention to skill when hiring. So I think we also need to lend our voice to those practice institutions. And I think the area of intellectual property rights, we suffer a lot as practitioners because we really don't talk so much about the problems we go through. So Liz Lenjo, let's liaise with Eileen Aluso. I hope she's here. And we try to reinvigorate the culture of IP practice in Kenya. If we are going to have a different way of practice. My brief comments on the dispute resolution structures in the bill, I'll call it the bill for the sake of brevity. I've seen it has just consolidated the three tribunals. It is very express that its purpose, and in the memorandum of objects, it expresses its purpose as to bring together the three tribunals under the Copyright Act, the IPT under the Industrial Property Act, and the tribunal under the ACA Act. That seems to have been the primary focus, and also to merge the three offices in those particular acts. And that's why we see they seem to have forgotten their other IP laws and other laws that govern IP rights. And they said along the way in the bill that that institution that will be created, the authority, shall also administer Trademarks Act and the Geographical Indications Act once it is enacted into law. When we look at how they have even tried to merge the tribunals, the bill creates independent provisions for each of those tribunals. It seems to suggest that there is separate tribunals, three of them, that are only going to be housed under one roof. So I think the bill is not the hallmark of elegance in legislative drafting, but I think it creates confusion as to how that tribunal is going to operate. When it comes to enforcement, under the copyright provisions, the authority is allowed to appoint inspectors. And also police have been declared inspectors or having the authority of an inspector through the Republic. Even customs officers have been declared to be inspectors. What this will do is to take us back to the problems we had in the initial days of enforcing copyright, where police officers would just want to arrest for making noise, but they do not know what is copyright infringement, and they do not know what should happen from that point on. When you go to a police station and you complain that your music is being infringed on, they will ask you which music has been stolen, and you have the compact disc. But back then, we had the DVDs and the CDs, and they will not understand what has been stolen. I think there is need to align that, whether we are going to have copyright inspectors and counterfeit inspectors who are separate and independent. The other retrogressive aspect of that bill is that prosecution of counterfeit offenses have once more been subjected to the control of the Director of Public Prosecutions. At some point in time, the Director of Public Prosecution had given authority to ACA to be able to prosecute. So we had ACA prosecutors who are prosecuting in magistrates' courts. And those days, practice was enjoyable because you're practicing with people who understand the subject. And along the way, that was taken out. Now, many of those ACA disputes have again stalled because the prosecutors either have not been sensitized, if they never had any interaction with the intellectual property rights or even counterfeits, they would not be motivated to take up those cases. Some of them were old cases which just needed a few procedures to be concluded, but the DPP Council are finding it maybe difficult or boring to pick up those disputes. So I thought this act should have just declared ACA as having the authority to prosecute without the necessity of gazettement by the DPP. So we are back again to the same problems. We've not solved anything so far as enforcement is concerned. The other problem we have is that while countries like Rwanda are civil law country, and the process of hearing disputes is inquisitorial, our system of dispute resolution in Kenyan courts and tribunals is adversarial. And you could see in the provisions directing making of regulations, the tribunals are required to respect the right to a fair hearing, they're required to observe the rules of evidence and the rules of natural justice. In the civil law countries, that is not a requirement. So one conundrum, that problem that is brought by this duplication is that we are going to have one authority that is going to create rights, to administer those rights, to be the registrar and custodian of those rights. They are going to hear disputes involving those rights. They are going to confer rights through a decision as to who should have the rights, including decisions like expungement. And then whenever there is another dispute in the market, they will have to investigate, and they have to correct evidence. They have to determine whether or not there is a case, then go to DPP to ask for permission to prosecute. So you have one investigator who has also created the lights and is also the prosecutor. It may have challenges when it comes to administration of the adversarial system of dispute resolution. One other thing that I have noted about this particular act, which I think has a good policy foundation, is that the Trademarks Act and all the dispute resolution mechanisms have not been affected, because the Trademarks Act seems to be intended to be enforced independently. That, in my opinion, seems to recognize that while the Registrar of Trademark is considered a tribunal under the Trademarks Act, the Register of Trademarks is not an ordinary judicial tribunal, but is a unique sui generis administrative tribunal. And therefore, it is not subject to the other rules or policy guidelines that affect other tribunals in Kenya. We would have wanted to hear whether that was the thinking of the draftsman, and whether in future we are going to have opposition disputes or expungement disputes also subjected to another form of tribunal. Thank you very much, Koros, for the opportunity to
Karibu
discuss and
sana.
have time to have this conversation.
Thank you. Thank you so much for giving us that insight. As we get the participants who want to speak, I'd like to invite one of you, Mr. William Wangi, who is a legal head at the Actors Guild, to give us his perspective on what IP reform he would like to see.
All right, thank you. Thank you so much, Chebet, and thank you, Sipit, for the good work that you're doing on that side, and even for extending the invitation to us and engaging us on this discussion, which is really close to our heart, considering that we are the rights holders, like you said, and we represent, an association of rights holders. And these are issues that are very close to our heart. And I will echo what everyone has said in this session, really on the fact that this is more institutional plumbing than it is, any type of rights reforms. And it's quite sad really to see that there wasn't any engagement with practitioners. There wasn't any engagement with, experts in the subject matter. So it's quite unfortunate to see that that is what happened. So my points were largely really, like you have already mentioned, on the IP bill. Just a sec. Sorry about that. So I was saying, for my engagement with this was really on the fact that what everyone has already said, and our fear really is on the when they merge Kipi, Kekobo, and ACA together, our fear is that, obviously there's the overlap in roles that they feel like has been happening, but I feel like that is wrong, because they were serving different jobs, and for us is that we will see the risk that it will move from an area where it's about creative sector nuance into looking into patents and trademarks and counterfeit, which someone has already mentioned. We rank quite high when it comes to the number of trademarks that we are getting, and that sort of thing. So for me, it's the focus will shift from the creative nuance really into looking into patents and trademarks and counterfeit enforcement, when we are not really looking at how can we also be able to encourage this sector when it comes to copyright and just the general IP protections around rights holders when it comes to creative matters. So for us, that's a fear that we have, because when you merge them, you might lose that what has already been really developed by Kekobo, which is the expertise around the work that we do, and sort of how we serve, and even the enforcement measures around the collections when it comes to our CMOs. That will be lost because the focus might just shift into what I've already mentioned. So for us, that's a big fear. There's obviously also the tax exposure, because it's not really clear on how we are going to be doing our taxes, especially like a lot of people have already said, when it comes to the right holders' engagement with the bills and the necessary understanding and knowledge around IP, it's quite low. And that's one of the things that we're trying to do, which I will encourage the people who've already spoken in this meeting to. We'll be getting in touch with you, but also just how can we be able to create coalitions or build bridges that will enable people who are already rights holders, people who are already working within the creative sector, to be able to grow their understanding when it comes to whether it's the the monetary returns that they're supposed to receive, or even the moral rights that they have, or even just whether it's WIPO and how they relate to that, or whether it's the Beijing Treaty. So all of these areas need to be broadened, or in a way sort of we bring that understanding to a level that the creative can be able to understand. So those are some of the fears that we currently have, because obviously they've already also mentioned about Kekobo's underfunding and understaffing, and how that has been hampering enforcement, and how that has enabled the CMOs to continue with poor governance, and creating very low awareness when it comes to right holders. How are we interacting with the tariffs? How do they come up with the tariffs? What's the engagement with the people that are paying for for the IP? So those are some of the areas that for us we feel like, especially when they merge, it will even create a bigger problem that is already in existence. And how will we have audiovisual performers and musicians, and we are all bundled up currently into risk, but this governance issue will not go away. So we need to be able to solve this governance issue, because the money is not coming to the IP holders, it's not coming to the rights holders. So that's an issue already. So for us, I think Hazel mentioned a bit about this in terms of how can we create a better IP culture in our country. And I think for us is education and awareness. How can we be able to ensure that there's education and awareness? And I'm happy with the work that CPT is doing, but how can we then be able to get the information and the insights that you have synthesized within your work? And how can we be able then to break it down into information and into data that our creatives can then be able to take back into their work? And how can we see that cycle that creates even a bigger and a broader IP culture within our country? And then also just the CMO governance transparency, which I know they've tried to solve with the tribunals, but we are not really seeing a way forward when it comes to how can we enable a better public audit of the collection and the distribution figures, and not just the licensing status, but how about that? How can we be able to look into those issues? And then there's obviously also the convergence. How can we see stakeholders within this sector? How can we unify to be able to ensure that we have greater influence when it comes to matters to do with IP, so that even for us as rights holders, we really want to be able to be connected to, whether it's lawyers or people who are working within this sector, whether it's research firms, whether it's lawyers, whether it's people who are developing an understanding around how AI will be affecting the IP area. So we really want to be able to then come together to have discussions and to have talks, so that then we can be able to, when the moment is right, we can be able to strike the iron when it's hot. And that means we are able to work more united than we are really fragmented at the moment, so that people are not just working in silos, but we can be able to work together. So thank you so much for the opportunity to share.
Thank you so much for even just sharing with us what you have. It comes out very passionately. And for me, what I'm taking away from that is talking about IP policy is just one part of the IP ecosystem, but the players around IP, the right holders, the lawyers, everyone has to play their part. And there needs to be synergy in that whole ecosystem to improve the IP culture. So thank you so much for sharing that perspective with us. I've not seen anyone else raise their hand, and we are also pressed for time. So I'll just um, read what Angie Tonga from Kipra has mentioned in the chat. And she was responding to what Liz had said, concurring that the draft policy is inconsistent with design of a national policy, where the policy interventions proposed are informed by a clear understanding and articulation of the policy issues. And she's also shared a link to the national policy guidelines, which I think is important for us to also review as we're looking at the IP policy. As we're about to close, we have just 7 more minutes. And I'd like to give each of the discussants 1 minute each, just to wrap up, to give any follow-up comments on what has already been shared by by everyone else on the call. And I'll start with Hazel, then we'll move on to Liz. We'll do ladies first, and then Mwangi and close with Andrew.
Thanks, Jabet. 1 minute really flies, so I'll try to be as quick as possible. So there's one thing as well in the policy. I think that I wanted to raise earlier about IP enforcement, and I think it's one of the systemic challenges that the policy is identifying as one of the things that is making the IP system in Kenya weak. Particularly in terms of enforcement, I think, and just riding on what Mwangi has mentioned in his intervention earlier, IP enforcement will require a different type of coordination, which I think the policy hasn't envisioned yet. And particularly, I know at INT we did a white paper a couple of years back in terms of how different enforcement bodies need to coordinate to deal with IP enforcement and IP theft, counterfeiting, IP theft, and piracy. And I know that IP theft is one of those things that stifles innovation locally, because there's a sentiment that if I come up with it, someone is going to steal it. And even for investor confidence, if I bring it to Kenya, this and this is going to happen. So one of the things that I feel like we should incorporate in the policy, and brings me back again to the culture, is how do you envision some sort of coordination between the enforcement authorities in the country? I'm talking about ACA, I'm talking about customs, I'm talking about KEBS. I know KEBS specifically deal with substandard goods as opposed to counterfeit goods. But that kind of coordination, especially now with the rise of e-commerce and social media, and we have counterfeit goods online and all these things, I feel like enforcement will require its own type of coordination, even with the police. Something that Mwangi mentioned, you went to the police station, you said your music is stolen. They pick up the person who has stolen the music, and then don't know what to do after. Different jurisdictions have adopted it in different ways. I know US has an IPR coordination center that has Homeland Security, FBI, ICE, Customs Border Patrol. The UK has a police unit specifically that deals with counterfeiting and piracy. I know Europe has one as well, a collaboration between Europol and EU IPO. And it's not an authority, it's basically a task force within that just coordinates the enforcement of IP issues. So I think that's another gap that I would identify in the policy. But I'm glad the discussions are ongoing. We'll attend the policy on Friday. I'm forgetting the words,
The
but
stakeholder
yes,
engagement.
my minute and more are gone. Thank you so much, Shepard. Thank you.
Thanks, Azal. Please go ahead.
All right. For me, my parting shot would be one, the IP bill must die. It needs to take a chill pill. We focus on the IP policy, on the national IP policy. If we have a well thought out IP policy, then our legislative reforms will make sense. I think just to add on to something William said, and also in tying with the conversation on commercialization, if the policy issues were well identified, then we would stop idolizing CMOs as the only commercialization strategy on matters IP. As is the draft policy just addresses CMOs. A well thought out policy issue would identify all the other issues and figure out better mechanisms for commercialization outside CMOs, because CMOs is just this much of the pie, right? So I think those would be my concluding remarks. I hope that the drafters will consult with KIPRA for a better drafted policy document. At least it's a good starting step, but I think where it is, it needs to be fine-tuned, and I'm hoping that the stakeholder engagement is not like the final and then it's passed. We are hoping that it's one of many. So where we can put our voice and say, please, let this not be the only engagement forum we are having, the better, because an IP policy is a big deal. It's a very, very big deal because it sets the tone. And if what we're setting ourselves up as a nation of innovation and as a center, as a Savannah, Silicon Valley, or whatever, then we have to get this policy right. So thank you so much, Chebet, and to CPIT for organizing this. And Mwangi, my term is coming to an end soon. Happily, please, if you would like to apply, we'll get you even busier.
Thank you so much, Lee. Thanks for sharing that. She mentioned that there's a public participation ongoing. So it's been going on from Monday. Today there's also one, there's one currently happening or should be concluding in Embu, Eldoret, Kakamega, and Mombasa. If you're in Nairobi, there is one session on Friday. It will be held at the Kenya Institute of Curriculum Development, KICD Ngara, from 9 to 12:30 p.m. So that's another opportunity for you to go and lend your voice there. Before I call Mwangi, I just want to read one of the comments from a participant, from John Katana, who says that the policy should provide a forward-looking framework for AI in the creative sector by protecting musicians from unauthorized AI training, voice cloning, and digital replication while supporting responsible innovation. Now move on to Mwangi. You have your 1 minute, and then we can have Andrew for his 1 minute before we close and release our participants. Thanks.
Thank you very much, Tibet. I think when it comes to registration, I always like looking at it from a positivist spectacle. The bill is here. It might be enacted into law. I think the buck stops with us, the IP enthusiasts and the practitioners and the experts, to take up a mantle and decide what should be the best for the industry. That's why I'm saying, whatever are the problems, let's speak about them broadly. And I particularly thank CPIT for organizing this, and also thank Liz Renjo. Liz Renjo is one of the very early apostles of the gospel of IP. We started IP check-in around the same time with her. And I'm very happy about what we are doing. What we are talking about as the real problems, the culture, the myopic view of the industry, failing to look at the big pie, looking at the hole in the donut instead of looking for the donut. that is upon us to tell the industry and to tell our leaders and politicians where actually the problem is. The government may be trying to save costs, but I think what even this institution should be doing is to look at how to make revenue or to earn more revenue, even from the existing registrations. When we look at, for instance, the KIPI, we have patent agents, over 400 of them. They're supposed to pay annuity fee at 2,000. KIPI never collects. So that's close to 1 million that is never collected by KIPI. Recordations are not happening. ACA is not doing anything. I asked them the other time what is happening with the recordation, because even international brand owners are asking about recordation. They say the system is down, it's coming up by August. But if recordation was working, the brand owners are willing and ready to pay whatever fees that is required to record their trademarks, so long as the enforcement will be effective. So I think we should look at those institutions from a commercial perspective instead of looking at them from a self-preservation point of view. Even if they come under one roof, things will not work out better. The government will still have to bankroll them. Thank you very much. We should have more for this. Thank you.
Thank you, Mwangi. Andrew, your final thoughts?
Yeah, thank you, Chebet, and thank you to my fellow panelists for the discussions. I found it fruitful. As a parting shot, I think for me, while researching on what a Kenya intellectual property authority would look like in Kenya, I decided to research another jurisdiction. And like any research, you try or you tend to go look at Western ideals and see whether you can implement them here. However, I decided to look regionally and looked at the case in point of South Africa, Uganda, and Tanzania, and whether their IP system or their IP offices are fit for use and whether we can apply the same here. So maybe I should throw this to the plenary and ask whether the IP officers we already have should be, should be done away with and put as an office within the business registration service. So as an office of the Registrar of Intellectual Property and Related Rights. And therefore have what we say IP as a creature of statutes be a creature of statute, and have the registration of IP within that office. So that's just my parting shot. I don't know whether it's good for anyone else, but thank you again, Shazet, for the conversation and for allowing me to be on the panel. And thanks for the participants and panelists as well. Yeah.
Asante sana pia Andrew. Thank you for that closing food for thought as we leave this webinar, but the conversation does not end. Hope to see those who are in Nairobi on Friday. Before we close, I'd like to share also what June Gashiri has posted as her thought, which is that all IP is commercial and should be looked at through a trade and industry lens. The creators or inventors, the rights holders, the works that are created, where they are registered and protected, the platforms through which they are exploited and traded, and the channels for payments, all must be considered in the broader policy and the future cannot be discussed without engagement in early education curricula, which I believe she's tied a lot of what we've already talked about from the very beginning, and it's great to see that a lot of what we are sharing resonates with most of us. And so I hope that we are able to give of our voices to the policymakers, and we see that the IP landscape develops in a way that is beneficial to everyone in the ecosystem and not just one sector. So with that, I'd like to close this webinar. Thank you so much for joining us, and we wish you a great afternoon. Bye.